Hope it is visible, Madhu.
Yes, sir, very much visible.
Okay, right. Thank you. So before starting, let us know what is civil and common law system. Common law is nothing but, the best example is India, where you have parliament enacted law as well as the judgments rendered by the Supreme Court of India. So the latest pronouncements by the Supreme Court will prevail over the parliament enacted law. So that is called a common law system. Whereas civil law system, the best example is UAE. Here the civil code that will prevail. The judgments, it won't prevail. So only the civil code will prevail. So we must understand the differences whenever you are going for international arbitration. As I have mentioned, UAE is the best example for civil law system. Also, since UAE is a cosmopolitan country where you have 90 plus nationalities are there. So therefore, they have the flexibility of adopting both civil and common law system as well as Sharia. Suppose if the business entities, they want to adopt common law system, they may approach the free zones, DIAC, DIFC, and then they can adopt the common law system or English law system, whatever. So that flexibility is there. So this is a fundamental knowledge we should have before entering into the arbitration arena. Okay. So in the next 2 days, we are going to have the glimpse of international arbitration. Having said that, it is kind of marathon, touching upon various topics. You need not worry about whatever is conveyed here. Our humble request is just receive, whatever is being touched upon. You have ample opportunity in the coming sessions wherein we will delve deeper into each of the topics. So just to put it into your ears, let us go through some terminologies. These are all not technical terminologies like our construction industry. These are all common terminologies, but this will make you familiarize with the arbitration system. I kindly request all other participants to mute their mic. Okay, so to start with, we will see what are the various dispute resolution methods available, and then we will compare the dispute resolution methods. We will see what is arbitration, what is international arbitration, what are the laws applicable in the arbitration, what is an arbitration agreement, who is an arbitrator, what are the duties and powers of arbitrator, what is about arbitration process, how it is happening, what are the rules applicable to the arbitration, what is an evidence. In any dispute resolution, evidence plays a key role. The decision will be taken based on the evidence provided by both the parties. What is a hearing process? This is the opportunity for the parties to present their case and witness issues of a dispute. Once we submit your case and witness, evidence, everything, arbitrator, he will frame what are the issues to be addressed. And then expert witness. It is a unique feature of construction arbitration, where experts of delay, experts of quantum, they will provide testimony. I'm an expert witness. I have appeared in many high-value arbitration cases. So this is an important element of arbitration. Because you may think that arbitration is only about arbitrator. Arbitration, it deals with many stakeholders. Arbitrator is also one of the stakeholder. And then arbitration award. What are the elements of arbitration award? The reasons for the decisions, the format, different types of awards. What are the grounds for challenging the award? And then how that award can be enforced. Enforcement is the culmination of the arbitration process. After all, we do the entire process for getting the money, isn't it? For realizing the money. So enforcement is the process. Since we do both domestic and international cases, from our experience, the real journey, it starts not from the invocation of arbitration. The real journey, it starts from the day we get the award, because the enforcement is the critical aspects of the arbitration. And we also will see about UNCITRAL model law. So these are the various aspects of arbitration we will be exploring in the next 2 days. So again, we want to re-emphasize, you need not take any notes and all. You need not corroborate the PPT slides. You kindly listen and receive what we are conveying to you. By end of the 2 days, you'll be able to comprehend what is the process. So it's kind of storytelling. That is what will happen in the next 2 days about the introduction. And once we move forward to the next level, we will go into individual aspects in deeper. Okay. So first we will see the different types of dispute resolution techniques. Okay. You all know that arbitration, mediation, negotiation, there are so many dispute resolution methods are there. Before knowing them, we should also know the difference between claim, dispute, and conflict. Claim is what you people are dealing in your day-to-day functions. That is within the contractual boundary. Once the claim is repudiated or rejected by your employer or engineer, then it becomes a dispute. To enter into arbitration, dispute is very, very essential. Only if you have a claim and if the other side did not object to it, then you cannot come into arbitration. To start the arbitration, you need a dispute in hand. You should have a claim and that should have been repudiated. So that is the fundamental requirement for the arbitration. You can see the life cycle of a dispute and a conflict here in this picture. Conflict is the bigger picture of the dispute. Once you fail to resolve a claim, it will become a dispute. And if you allow it further, it will become a conflict. So these are the various mechanisms for resolving the different levels of the disputes. Okay. Conflict avoidance, that is the starting point. Even though we are arbitrators, we always advocate dispute avoidance. Dispute avoidance, how you can achieve? By due diligence, contract management, by maintaining contemporary records, by presenting a due diligence report from time to time. So thereby, you will achieve a dispute avoidance and further conflict avoidance. And then dispute resolution, the first form is negotiation. Negotiation, you all know that. It happens between the parties. There is no third party involved. Mediation. Here, there will be a neutral, impartial mediator will be present. What he will do? He will facilitate the discussions between the disputing parties. Okay, it is a unique system. You may think that mediation is an ordinary method. No, it is not so. Okay, myself and my colleague Madhumitra, we both are mediators. Mediation is gaining momentum worldwide, especially in India. There is a robust act has been enacted last year, Mediation Act 2023. So mediation is very unique, wherein this is the only system where parties will decide the outcome of the dispute. Whereas if you go to arbitration, the arbitrator will decide. If you go to court, the judge will decide. But mediation is the only process where parties will have a say on the outcome of a case. Okay. And then we have the contemporary development, mid-arb process. Here, the hybrid mediation and arbitration will go hand in hand in the dispute resolution process. And then arbitration. Okay, so that is the focal point of our learning. So from now onwards, you will hear about arbitration in many places, in many sections. So what is arbitration? Here, the disputes are resolved by an award. Award is nothing but synonymous with a judgment by the court. This award is pronounced by the independent tribunal. Okay. The tribunal is either agreed by the parties or appointed by the court. It depends upon the jurisdiction. In India, if the parties, if they don't agree, then they approach the court and court will appoint the arbitrator. Similarly, in other countries, in UAE and all, you have institutional arbitration. Okay, we will see one by one. So arbitration, broadly, it has two domains. One is ad hoc arbitration, another one is institutional arbitration. Ad hoc arbitration means here the parties will decide everything. Parties will decide who will be their arbitrator. They will also decide what will be the language, what is the procedure, where they will conduct the arbitration. You know, the procedural aspects, everything will be under the control of the parties. Ad hoc arbitration is predominantly practiced in India. In India, you can say 90% of the cases are being administered in ad hoc arbitration method. Whereas institutional arbitration, here the arbitration is administered by institutions such as DIAC, Abu Dhabi, ADGC. So these are all institutional arbitration. ICC, LCIA, these are the institutions. They have well-defined rules to conduct the arbitration. They also undertake right from the invocation, appointment of arbitrators, conducting the process, rendering the award, and then any corrections. Up until that, they will take care of all the procedural aspects. And if you look at the life cycle process of any arbitration, institutional arbitration, they provide robust arbitration award. Why I'm saying is, the very objective of an arbitration process is to get an award that cannot be challenged in any court. That is very important, isn't it? Suppose if you get an award from somebody, some X or Y, and if that is challenged in the court, and if the court finds that it is not tenable, then what is the point of conducting the arbitration, spending huge amount of money, isn't it? In that aspect, institutional arbitration, they provide robust and diligent arbitration award, resilient award, which cannot be easily challenged in the court of law. Thereby, parties, they can enforce the award and realize the money, which is the ultimate objective of the arbitration process. So the definition for arbitration, Lord Justice Raymond, it's for your soft reading. Okay, arbitrator is a private extraordinary judge between party chosen by their mutual consent to determine controversies. For if they observe the submission and keep within the bounds, their sentences are definite from which there lies no appeal. So, in real life, arbitrators, even though they are the product of contract, they are more powerful than the judges of the court. That is the reality. They have more powers. In certain aspects, their decision cannot be challenged. Okay. So we will see. And then litigation. Litigation is a court process. Court process, you know that it is very long, very tedious, complex process. A common man cannot comprehend. We are advocates. Even we cannot understand sometime, what is the process they are undertaking. Now, we will quickly go through the outline of arbitration, mediation, etc. So arbitration, it involves acts for administering the arbitration process. Every country, they have arbitration act. In India, it is Arbitration and Conciliation Act 1996. In UAE, it is Federal Arbitration Law is there. Okay. And then internationally, you have UNCITRAL Model Law 1985 and then further amended. Okay. So for all the countries, the Arbitration Act is based on the UNCITRAL Model Law. So therefore, if you are familiar with the UNCITRAL Model Law, then you can easily comprehend the arbitration law of any country. In our initial meeting, I think Bindu, she has asked this question. how to deal with the international laws. So the answer is, once you are familiar with the ancestral model law, it is very easy for you to comprehend arbitration law of any country, because almost all the countries, they are based on the ancestral model law. So now we'll quickly do the comparison of different dispute resolution mechanisms. In terms of formality, speed, flexibility, cost, etc. So formality wise, mediation is an informal process. I have already mentioned parties are the deciding authorities. Mediator will only facilitate the discussion. He will identify the options between the parties, and thereby he will facilitate the interactions between the parties. And then once the parties they are successful in removing the differences, then the mediation settlement agreement will be formed. That also in consent of the parties, the mediator will prepare the mediation settlement agreement. So it is an informal process. Whereas arbitration, it is a formal process, but when compared to litigation, it is a less formal. Why? In the court of law, only the advocates, they will go and present, isn't it? Only the court will decide what is the procedure. Whereas in arbitration, party autonomy, that is the, what you call, foundation of the arbitration. The fundamental element of arbitration is party autonomy. Party, they can decide who is their arbitrator, what is the rules, where they can conduct, what is the language, everything. There are a lot of party autonomy is there. So therefore, it is less formal than the court process, but higher than the mediation process. And litigation, it is totally formal process, complex and formal process. Speed, in terms of speed, mediation, you can conduct the session in a very speedy manner, because here the parties, they have the control. If the parties, if they are able to resolve the differences with the help of the mediator, then the process will be much quicker. Moreover, as I have mentioned earlier, different countries, including India, they have enacted Mediation Act, and now it is a legal process. So by law, the time limit is fixed. So within the time limit, they need to conclude the mediation process. So therefore, mediation is the, you can say, fastest mode of dispute resolution. Okay. Arbitration. Arbitration, the general perspective is it is fast. It is fast. They can be concluded in a very speedy manner. However, it differs from jurisdiction to jurisdiction, where you are. Okay. If it is in UAE, for example, yes, it is. Even though the Act doesn't specify the time limit, there the rules will prevail, because law is different, rule is different. That you have to understand. Also, in UAE, almost all the arbitration cases are conducted by the institutions. So institutions, they have a well-defined rules. The rules stipulate that once the arbitration process is concluded, once the hearing process is concluded, arbitrator, he must render his award within maximum 1 or 2 months. Okay. Whereas in India, the story is different. That you will come to learn, the next course of time. So therefore, arbitration, even though in book it is speedy process, The speed depends upon which jurisdiction you are. Litigation, of course, that is the slowest process with its own complexity. That is a slow process. Cost wise, if you look at mediation, mediation is the very, very affordable dispute resolution process. Okay. And in the mediation, you need not have advocates. The parties themselves, they can represent. Again, depending upon the complexity of the matter, advocate also can represent the parties. We do both commercial and civil mediation. Commercial mediation is where the construction disputes, will come under. So for the commercial disputes, they are, bit complex. So the advocates are there. Even then, cost-wise, mediation is the least economic and affordable dispute resolution mechanism. Arbitration, again, it depends upon which mode you are selecting. And also, even though we are arbitrators, practically, arbitration is not a fit for all mechanism, fit for all disputes. If it is a less complex, less value, then you need not go to arbitration. You can resolve it by other means. Okay. So therefore, if you don't follow these rules, then arbitration is a bit expensive. Okay. The arbitrator fee, the administration fee and all, it is quite high. If you look at the survey reports conducted by ICC arbitration, it says about 95%, more than 95%, it goes to the process of arbitration. Okay. So therefore, arbitration is not least expensive. It is expensive depending upon the nature of your dispute. And of course, litigation with its long-term dispute resolution process, it is naturally expensive. Okay. And then confidentiality wise, mediation is a very, very confidential process wherein parties are not allowed to disclose anything. Similarly, the mediator as well. Okay. So there is a comparison table. It shows for different dispute resolution technique, which is ideal. Okay. For your soft reading. So this is about comparison of various dispute resolution mechanism. It brings to the end of session 1. Now we will have a poll. Madhu, will you do that or?
Yes, sir. I will initiate the poll.
Yes, please. Don't worry about the poll. It is just to refresh, whatever we have discussed so far, and just to engage yourself.
Yes, the poll has started.
No, Madhu, you have opened wrong poll.
Sorry, sir.
Okay. You want to say something, Madhu?
Yes, the question is most expensive method of dispute resolution. The choices are mediation, arbitration, and litigation. I think 69% has answered litigation and 38% has answered arbitration. The correct answer is litigation.
Litigation, yeah, but that's a practical answer, they are given. Sometime you know that.
Yes.
Yes, arbitration is expensive. Okay, good. Okay, so we'll move on to the next session. Okay, so next session is introduction to arbitration. So you can say that is the crux of our session. Let me open. Hope it is visible.
Yes, sir.
Okay.
PPT is visible.
All right. All right. So in this session, we will quickly run through what is arbitration, how the dispute is referred in the arbitration, who is an arbitrator, how he is appointed. Quickly, we'll see. We'll just have a quick glimpse of these things. So what is arbitration? That we have already seen. And we will again, time and again, we will see what is arbitration. Because, just to register yourself, you may have your own perspective, but let us have the right one. So arbitration is a private and confidential process between the parties, and the arbitrator and the parties are free to agree how their disputes are resolved. The court shouldn't intervene except to assist the administration of the process. So this is what the judgment in the MMTC Limited versus Sterlite Industries case it said about. So fundamental principles of arbitration. The arbitration process, it should ensure principles of natural justice. That means nobody should be left unheard of. And a person, he shouldn't hear his own case. Also, the parties, they should be given equal opportunity to present their cases. The arbitrator, he must be independent. There shouldn't be any conflict of interest. This is the very, very important element of arbitration. The arbitrator, he shouldn't have any conflict with the three aspects. Number one, he shouldn't have conflict with the case outcome. Number two, he shouldn't have any conflict with the parties. Number three, he shouldn't have any conflict with the counsels, that is the advocates. Okay. So first, whenever somebody, if somebody is coming to us to resolve a dispute, first what we will do is we will do the conflict check. Because if you have a conflict, that will be the very basic element for setting aside your arbitration award. So therefore, the arbitrator, first thing what he will do is he will do the conflict check. Then only he will accept his appointment. Okay. And then neutrality of adjudication. That is very, very important. Also, the main objective of arbitration or arbitrator is to render an award that cannot be challenged or set aside. That should be a resilient award. Okay. So therefore, his adjudication process, that should be very, very robust. That he should apply due diligence in all aspects from the inception up until the rendering of arbitration award. Okay. So for invoking arbitration, to start an arbitration, what are the important aspects? You should have arbitration clause. If there is no arbitration clause in the contract, arbitration cannot be invoked. There should be a dispute, I have already mentioned. Limitation period, it differs from country to country. If it is in India, from the date of dispute, he should have started the arbitration within 3 years. In UAE, I think it is 12 years. It differs from the type of the dispute, 12 years to 15 years, UAE. So that also you must check before starting your arbitration. Then there must be some pre-arbitral steps such as negotiation, amicable settlement, dispute adjudication board, which is common in the FIDIC contracts. If that is mentioned in the arbitration clause, the parties, they should first exhaust these pre-arbitral steps before stepping into arbitration. The arbitration, it involves 3 types of laws applicable to the arbitration process. The first type of law is, what is the subject matter of the dispute? In construction, the subject matter of the dispute will be contract, isn't it? So if it is a contractual dispute, then the respective law will apply. If it is in India, it is Indian Contract Act 1872 will apply. If it is in UAE Civil Code, the respective article dealing with the contractual matters will apply. The next type of law is the proper law of the arbitration agreement, which is the arbitration act of the respective country. If it is in UAE, it is Federal Arbitration Law. Okay. If it is within the DIFC, then they have their own arbitration act. Okay. If it is in India, then Arbitration and Conciliation Act. Internationally, it is UNCITRAL law. Okay. So third type of law is the proper law of the conduct of the arbitration. That is the rules. If it is an institutional arbitration, then the respective rule will apply. So these are the 3 types of laws applicable in the arbitration. In addition to that, there are some soft laws applicable. What is a soft law? It is not a mandatory, but these laws are mandatory. You cannot deviate from them. Best example for soft law is IBA guidelines, International Bar Association guidelines for conflict check of the arbitrator, that you can download. It is a free source. So that defines what are the conflict grounds for the appointment of arbitrator. Okay. So types of arbitration: domestic arbitration, that is both the parties are within the same country. International arbitration, one party belongs to another country. Institutional arbitration, we have already seen. Ad hoc arbitration, decided by the parties, everything. Okay. And then you have fast track arbitration, contractual arbitration, statutory arbitration. What is statutory arbitration? In India, there are several statutory laws are available. For example, electricity law, Telecom Act, okay, National Highway Act. So if any disputes arising in these domains, the respective law, they have arbitration provision, that is called statutory arbitration. Then you have foreign arbitration. Suppose if 2 parties belong to same country, but they prefer to conduct the arbitration in another country, so that is called foreign arbitration. Okay. And then in arbitration, I have already mentioned, it is not only about arbitrator. You have arbitrator and then parties, tribunal secretary, okay, case manager, and many more are part of the arbitration. So therefore, apart from whatever knowledge you are gaining, suppose if you want to practice arbitration, then you must think beyond arbitrator. You may become case manager. You may become tribunal secretary. They assist the arbitrator in conducting the arbitration. Okay. And then also we'll quickly look at duties of the parties, duties of the arbitrator and all. So arbitration clause. In any contract, you will see arbitration clause. Okay. These are the elements of an arbitration clause. We will see in detail in the subsequent sessions. So it will have seat of the arbitration, number of arbitrators, language of the arbitration. Kindly mute the mic. I think somebody has. Law governing the arbitration, substantive law, arbitral institution, all these things will be mentioned in the arbitration clause. Somebody has opened the mic. Kindly mute. Then management of arbitration. So arbitration, the entire management is to ensure that the procedural aspects are adhered to so that the timeline and the cost is met within. Okay, there is no unnecessary delay involved. Okay. Also, the management of arbitration, it should ensure that the process, it follow the natural principles of natural justice so that every party is allowed the opportunity to present their case. Okay. Then duties of the parties. Parties, they have duties to adhere within the timeline, the submission procedures. Okay, so that the arbitration process is being conducted within the timeline. Okay, so the duties of the parties that will be decided in the preliminary meeting. So this preliminary meeting that will be explained by my colleague. Okay, and in the preliminary meeting, the arbitrator, he will explain what are the duties of the parties. Okay, just for your knowledge purpose, I will display a preliminary order. Okay, in the next session, I will show you how a preliminary order issued by an arbitrator. So that will define what are the duties of the parties. Okay, so this is the end of session 2. Now we will do a small poll for the session 2. Madhu?
Yes, sir.
Meantime, if you have any questions, you can post it in the WhatsApp group. We will address them one by one. Everyone has participated, isn't it?
Yes, sir.
Yeah.
So the question is essential requirement to invoke the arbitration, and the options are arbitration clause, disputes, and the third option is both. So 71% has answered both, 1% has answered dispute, and 3 has answered arbitration clause. And the answer is both. Without dispute, there is no adjudication process, and without an arbitration clause, the arbitration proceeding and adjudication by arbitration is not possible.
Okay. Thank you, Madhu. So now you may continue with your session.